Okay.
Council, do you have an open statement?
I'll wait open.
Sir Quinn, if you want to give an opening statement now, you can, or if you want to defer to the start of your case, you can. It's your preference.
I'll briefly give one. We're here today because Chad made a serious mistake. He was in pharmacy school, and he went out to Arizona to finish his last rotation. And he got on the dating app. Got a date with someone he thought was of age, that represented to be of age, 18 years of age, and others. Over his certain parameters too, and she looked to be that as well. He found out after their relationship developed into a sexual one that she was, I believe, only 16 years old. Apparently she had gone and told her doctor that she was having sexual relationship with older men, and the doctor reported it as mandatory reported it to the proper authorities, and then that's, came about with Chad being charged with what he was charged with. Like I said, all this happened in Arizona, so he worked through that process with the criminal lawyer out there, and all the charges were eventually reduced to one charge of sexual conduct with a minor, which the judge stated in the sentencing order that it was what's called an undesignated felony. In other words, not like class A, B, C, or D, and said it should be treated as a misdemeanor unless and until it is designated as some level of felony. So, and one of his defenses was that he wanted to go to trial. It was just too risky when you get in a situation like this. One of the defenses in Arizona, and it's not in every state, is that if you were under the belief that the person was 18 years of age or older, and then they actually weren't, then it's not like you automatically get a conviction anyway. It's maybe like in Arkansas, but you would in Arizona they have raised it as a defense. He wanted to go to trial and raise that. It was too risky. He was offered this plea bargain, and he was advised to take it instead of getting potentially multiple felonies and many years in prison. He got took the charge of sexual conduct with a minor, which the judge classified as non-dangerous, non-repetitive, and said it should be for 10 years of probation. A lot of monitoring conditions, and should be treated as a misdemeanor, which kind of, so that's the basic of what happened. There's a lot more. He's got character references. He's got Walgreens still wants to hire him. He was doing well at Walgreens before all this started. They put him on a management track, those sorts of things. And his boss, supervisor, has written back, written a letter to the board saying that he could, Chad could keep Chad worked with his teenage daughter in high school. He could keep his teenage daughter and work with her now. And he would have no problems, that he was a respected person at work, and this just totally caught him by surprise that this happened. So you can read that letter yourself, but he's going to have that opportunity and that type of supervision too, because the supervisor obviously knows about all this. And Chad can explain that. Of course, he's being supervised by a probation officer. He's being supervised by the sheriff's office in Baxter County. He's in Mountain home. And then he's got all types of random polygraphs that can be done, drug tests, no alcohol drugs. His computer can be monitored at any time. There are a lot of eyeballs on him right now. So with that said, what we're going to ask you is that the board's primary purpose is to protect the health and safety of the public, and that's number one. But if they can do that, the board can do that, and then still serve its secondary purpose of rehabilitating people, helping people that have run into some type of situation, such as drugs and alcohol or crimes, or whatever it is, that that can be done safely. Then Arkansas law says you should do that. We passed a law in 2019 that I want to talk about. That basically was a law that says we want people to work even if they've had felonies. We want people to be able to come out, get through whatever they did, and get an occupational license or a professional license, and that's what we want. Now, here's certain offenses that if you commit it, you're going to have to come to the board and get a waiver. That's why we're here today. But and then there's stuff like murder and stuff you can't get a waiver on. The really serious stuff. But that gets me to the point of the law that the board is citing, and it's on page 3, and it's 17 says 17.2.102, but it's actually 17.3.102, and that's the law that Arkansas passed in 2019. It kind of consolidated a bunch of mismatched laws that each board had and said, here's kind of how we're going to treat people with a criminal record. And it goes through that. The problem, and then so the board says in these allegations that, if it's any felony listed in 17-2-102, 17-3, that's 102. If it's any felony listed in there, then you're ineligible to have a pharmacy license. That's an older law, and people probably know this, but, if two laws can't be reconciled, then the courts are gonna assume that the newer law was meant to, by implication, override the old law. So, you got that to kind of compare and go through, but he's not, the only felony in that law is on page 18, and it says, of that law, it says sexual assault in the first degree, second degree, third degree, and fourth degree. So if you look up each one of those crimes, sexual assault in the first degree is a class A felony, second degree is a class B felony, third degree is a class C felony, fourth degree is a class D felony. He didn't get that type of felony. He got an undetermined felony, is what his actual sentencing order says. It should be treated as a misdemeanor. So we're saying that he's here to seek a waiver, but we don't want to waive the legal argument that we don't think that statute applies. So but he did, while all this was going on, he voluntarily entered into an consent agreement where he said, I'm not going to practice until I clear up this business in Arizona. And now he's done that. He's back here. He's registered with all the people he's supposed to register with here, the best he can so far. And he's asking to have a second chance with appropriate restrictions in place. That he's not just going to be running around working in a one-person store or not being monitored by people or people not knowing exactly what he did. That's going to be that situation for him if he's fortunate enough to get his license reinstated. Thank you.
First witness.
That's unusual. I agree with respond to the legal comment that Mr. Quinn raised and stuff. That was as far as 17.3.102 applies, that is, Mr. Quinn pointed out scrivener's errors in the hearing notes. That should be 17.3 rather than 2. I guess I'll orally move to amend that because that is the proper applicable statute. That was perhaps an error as a result of using the original version of the act. Did say 17.2, should be 17.3, but in any event, I'll note sexual assault in the fourth degree is in that statute. That is the criminal charge and conviction that tracks with this. I know what the statute says, and I know what is in the sentencing order. Nevertheless, the sentencing order shows a plea of felony. My argument is going to be this statute very much does apply to the situation. I'll note sexual assault in the fourth degree does have a misdemeanor provision to it as well. It's an A misdemeanor for similar acts. With that, I will call Brenda Craig.
Councilman members.
Thank you. You state your name for the record, please.
Brenda McCray,
And Dr. McCrae, your current lawyer.
the Arkansas State Board of Pharmacy.
What do you do for them?
I'm the assistant director
And how long have you been so employed?
since 2011.
And in addition to serving as assistant director, you're also a licensed pharmacist.
I've been licensed as a pharmacist since 1986.
And in your capacity as assistant director, you review applications for licensure and renewals.
I do.
You familiar with the licensure file and history of the respondent today, Chad Dix?
I am.
What's his current licensure status?
He's currently under an agreed order with the Board of Pharmacy not to practice in the state of Arkansas or any pharmacy.
And that agreed order, is that exhibit 7?
Yes, it is.
Exhibit packet. Let's let's start there and work backwards. Why did this agreed order need to be entered?
The order was put in place by our previous attorney, and Mr. Dix, he did send our previous attorney and myself actually an email that he had been charged with a crime, and that, which is actually under Exhibit 8, and that he was writing to seek a hearing with the board. He renewed his license in December 1, 2021, he answered yes to the question, have you had charges against me in the last 2 years?
And why did he answer it that way?
Because he had been arrested on 5 counts of the order of hearing. He had been arrested for sexual conduct with a minor, a young lady who was 15 years old, and had been charged with several counts regarding that.
And did he send a statement regarding that?
He did.
Where is that? Is it that?
It's exhibit number 10. This is actually a letter to the board members.
How we don't need to read the whole thing, because does he acknowledge?
He says, I was charged with the following 4 counts of felony sexual misconduct with a minor, felony luring of a minor for exploitation, and felony aggravated luring a minor for sexual exploitation.
And what kind of, would it be fair to characterize this as a summation of his viewpoint what happened?
Yes, I think so.
I won't ask you to read all of that, so it's already in the record. So, prior to this, you said it was on renewal, he disclosed all this?
Yes.
Okay, so has he been licensed with the school previously?
Mr. Dix applied for a license, I believe, in August of 2021. He applied for a license by exam, and on August 25th of 2021, he actually sent in his paperwork so that he could become licensed after being taken the math test.
Those documents are those exhibits 5 and 6.
Yes, sir.
See, hold licensure with any other states?
He held a license with an intern license in Arizona, that he surrendered that. That's under exhibit number 4. It was a voluntary surrender in lieu of hearing, is what I understand from this document.
Any other states he had licensure in at the time he applied here?
He did have, I'm trying to remember, I think on his pharmacist application, under exhibit 6, he held a technician license in Texas, an intern license in Texas, an intern license in Nebraska. And the intern license in surrendered in Arizona.
So, exhibit 11, what's exhibit 11?
Exhibit 11 is a narrative from the Glendale Police Department about the incident. It's an internal document. And the other thing about the entire investigation and process.
What is exhibit 12?
Exhibit 12 is just a criminal court case information. Case history that came from Maricopa County Superior Court website. It basically outlines the court case as it began. Started with the true bill of summons listed on 8/17/2021, and it goes through a disposition report on 9/22/2022. And it includes the sentencing order from 8/31/2022.
The sentencing order itself, is that 13?
Yes.
What does that say?
It says that in lieu of, there's a plea bargain, and he is going to plead guilty There's a waiver of trial, the defendant knowingly, diligently, and voluntarily waived all pertinent constitutional appellate rights and entered a plea of guilty as amended 13-1405A, sexual conduct with a minor. The offense is 10/25, 2020, 10/26, 2020.
How long does it state he's going to be on probation?
It's going to stay simply on probation for 10 years.
So let's look at the conditions of the probation. Are there any of the conditions stick out to you?
He does have to register as a sex offender. His computer usage is to be, there are some special conditions of his probation on his computer usage. He has to have an interstate compact agreement with the state of Arkansas so that he can leave Arizona and come to work in Arkansas. He can't consume any alcohol, he says he needs any substances containing alcohol, no contact with the victim.
That computer usage condition, would that pose an issue?
It's possible, you know, when you work in a pharmacy, you do have access to computers, both those that access the internet for ordering purposes as well as looking up other things, and we have a pharmacy system also that may actually access the internet also.
And Dr. Craig, you are familiar with the criminal background check and conviction provisions of Title 17 right now. Does this offense match anything that would be a disqualifying offense under that statute?
I would say it matches the unprofessional conduct.
And sexual conduct with a minor, or would there be an Arkansas statute that would match up with as well, if be a criminal violation?
There would, I can't tell you what that statute would be, but I do know he has to register as a sex offender in the state of Arkansas.
Anything else about this case that you want to be aware of? I'll pass the witness.
Counsel, cross-examination.
Good afternoon, Dr. Curry. You said he did just enter into an agreement not to practice when the board asked for that.
Yes.
And then when it came time to renew in December of 2021, he honestly disclosed that this was going on in Arizona and sent, looks like an email explanation, maybe a statement.
He did, it's an online renewal. We were not notified prior to this that there was any investigation or any charges being made.
And then when he had applied initially for his license, are you aware that he had not been arrested at that point?
I'm aware that according to the police report, he had obtained an attorney in January of 2021 and had revoked his rights to remain silent, which was prior to him filling out this application.
And do you know if that was an arrest? Is that?
I believe he was indicted in August of 2021.
Okay.
I think actually the indictment maybe was August 17th of 2021, and this letter to get his license by examination was actually on 8/25 of 2021.
Do you know if he had actually been arrested?
I just know that there was an indictment on it.
And then I believe you said that you believe this to be unprofessional conduct and then fit within one of the felonies in the 17-3- 102, I believe.
102.
Right?
I did say that I believe that professional conduct did fit into that.
And then, are you aware that 17-3-102 what was thought about the legislature when we did that? You know that the purpose of 17-2-101 and the following chapter was to keep Arkansas Working Act of 2019. Did you see that?
To be honest, no, sir, I'm not an attorney, and I didn't see.
And it states in the purpose, did you see it stated that to ensure hardworking Arkansans maintain occupational licenses, professional licenses, while trying to maintain debt-free lives and trying not to be impoverished? Did you see that? in this?
I did not see that.
And do you see where that law also said that boards can no longer use generic vague terms like
Moral turpitude.
moral turpitude,
I didn't see that.
that kind of stuff.
It did not list on professional conduct in that group that I can do.
And it said such as but not limited to moral turpitude and something else, yeah. Like a character or something, yeah. So, you believe that, I take it that the term unprofessional conduct or some of the language is used in our pharmacy statutes, that they are just vague type generic terms that could fit almost anything if you want.
Well, I think that fit sex with minor.
When you didn't know about it,
I don't know that I agree with that statement, so.
do you have any evidence that shows otherwise?
Only the police report that states that he wished he knew, that he wanted to believe that she wasn't victim. In the police report that states that.
Did you see it was just after she told him after they already had sex?
I believe that there were more than one occasions, there were pictures sent back and forth via a telephone after he was aware that she was victim.
That's your opinion.
No, that's in the police report.
That's all I have, sir.
Board have any questions, Ms. Witness? Seeing as there are no questions for this witness, counsel, do you have any redirect?
No redirect. I just want to ask that Dr. Craig stand down.
Stand down. Subject for recall. No witnesses.
Rest, there's a right for the
Counsel, you may proceed.
Oh, Chad Davis, you already been sworn. Would you tell the board your name and address, please?
Chad Anthony Dix, I right now reside at 3940 East Mountain Home.
Can you give the board just a little bit of background about how you even decided to become a pharmacist, how long that took you, and then where you went to school?
So I started at Walgreens working there as a second job. I was never a cashier when I was 26. And during that time, they kept being happy with my performance and they kept asking me to call and move up. I like the overnight shifts. I told them no repeatedly, but after about a year, they convinced me because the money was much better. And I could have left my other job that I was at for 8 years at a restaurant. As I was working all the way up through Walgreens, I kept getting promoted to assistant manager, then executive assistant, to eventually store manager. And during that time, I've worked with, realistically, hundreds of pharmacists, and a lot of them always told me that the way I was able to analyze things and think through things, that if I wanted to do something in the future, pharmacy school might be something for me. Of course, just laughed it off because I don't know if you read my previous statements, but I was a high school dropout. Came from what would be considered by most people like problematic and things like that. But basically, I suffered insomnia all through my teenage years and depression and things. It affected my going to school and eventually had to leave and live on free. So basically, it felt like I was just a failure my whole life. And so people would tell me, like, you can actually get a degree and things like that. I would just laugh because that's not me. You know, I can be a store manager and I can do the best I can in this business, but I feel like I could be destined for something better, but it doesn't seem realistic. In my 20s, when I was 19, I got my GED, so at least I had that going for me. So around 34, 35, I decided just to throw caution to the wind and take a couple of classes at college to see what would happen. And so I took the basics, college algebra and composition just to kind of see how it went. And then what I would do is go to community colleges after I left Walgreens, 8 to 5, 8 to 5. And so throughout that process, I realized that school really wasn't that hard. I hated it when I was younger, but it was bad now. And so I continued on. I went through normal classes, started going through biology and chemistry. And once I went through my first chemistry class, I enjoyed it. When I talked to my pharmacist about that, they said that's all pharmacy is, it's mastering chemistry and being able to use that in terms of physiology and things like that. So then I started thinking it was possible. So I went through a couple of years as biology and pharmacy, as you know, those have labs with them. So at some points I was only able to take 1 class a semester, 2 classes a semester. And then eventually started getting into PharmaCast's website, which told me what schools required. So when I started taking that, I gave up, thinking electives and started going for managing scientists, so I could get through it, things like that. And then I started to apply around 2019. I started getting my application together and I started applying to schools. Had an interview in Midwestern Arizona and Creighton and Omaha. My father, I hadn't known until I was 21, lived in Omaha, and I thought this was a great opportunity for me to kind of get to know him and reconnect with him. So I thought that was a great option too. And so I started aligning my classes with what Creighton and Midwestern required, and then went to my interviews and was accepted. When I was accepted at Creighton, I saw that I would have 1 art class from getting my associate's degree, so I figured I'd just do that. So I was actually able to log on a college stage 2 before I got to pharmacy school with the class. And then in 2017, I started pharmacy school.
And so you got out of pharmacy school, you got an opportunity to start with Walgreens.
So I left Walgreens because I went to Creighton full-time and I couldn't maintain my job as the way I was able to perform the duties that they expected me to do. So I quit the company on good terms, looking that I was retiring for one. Went to pharmacy school, and when I got out, it was an option. But when I did my rotations in hospitals, I really enjoyed it. And I'm sure most of the board probably did too. Usually, so it was like the last resort. So I went through hospital rotations. I did 3 ICUs, including 2 at St. Joseph's, and really kind of latched onto that. Felt like this is what I was going to do. Maybe ICU or maybe emergency room, something like that. And then when I graduated, of course, posted to social media, my graduation pictures and things like that. And my former protege, one of my assistant managers while I was a store manager, who worked under me, he lived up here in Arkansas. And told me that they were desperate for help because they can't get anybody to come up here and the company was offering sign-on bonuses. So I asked him where it was and how far away it was, things like that. I looked it up. During my time at Creighton, I would come back home once a month to Dallas to see the family, things like that, and go back. And I saw that Mountain Home was actually closer, so that would have been more beneficial to me. So it gave me an opportunity for 2 years in a company that I kind of already was familiar with and that I could maybe grow. And then the idea being to revert back to Dallas or wherever we decided to move to once I got promoted to pharmacy manager. During that time, I created what I think is some very good work practices that weren't being used there because this pharmacy has very bad evaluations and reviews from the public. They were very behind, they had high turnover, things like that. And they really wanted like a settling atmosphere, and my protege thought that of me. That is something I usually bring a positive work environment. I'm very good at mentoring people, I usually take people in my wing and give them all my kind of attention. And then I'm also pretty happy-go-lucky in a work environment to try to keep people happy and light and laughing and things like that. And he said that's exactly what was missing. Plus he had a young pharmacy manager that was promoted because there was really no other option. And he felt like my influence would have been beneficial to him as well, because some people may have said that, they weren't getting along as well with him as they wanted to.
Let me stop you right there. When all this happened in Arizona, you lost that job.
And yeah, so once I didn't lose it until I gave the order to surrender my license or not to practice with you guys. I asked if they would put me on administrative leave until the resolution of this, because I thought honestly, my hearing in June was gonna be the resolution, because they tend to go to trial a month after that, and I mean, I thought I was going to trial. And so, I get the agreement with you guys not to practice until then. And that's what
You've honored that agreement.
Yes, sir.
Now, you have a letter in response to the one, on the first page, on the statement section. It's from a Kevin Scarborough. Can you just tell the board who Mr. Scarborough is?
Yeah, he was my protege that worked underneath me. He was a Walgreens store manager for many years, left to start his own business, and then wanted to come back to the company. When he came back, I happened to have another one of my proteges promoted at the time, and so I had an opening, so they put him with me, and I worked with him for a couple of years.
And did he basically say that he believed you to be reliable, hardworking, honest, and one of the best trainers he's ever worked with during his time at Walgreens?
He said that.
And then he also said you worked with his teenage daughter when she was in high school, and that he would still have no problem with you working, with being around her again and working with her.
Correct. So what he wrote, I did see what he wrote, and what happened was when he got promoted to his own store back in Dallas, his daughters, he has twin daughters, and when they were able to work, one of them applied to my store, one of them applied to another store. And he thought that I would be a good influence on what his daughter at the time. After he learned about everything, because he's one of the few people that know the entire story, and he on his own volition said that he still felt like he would trust me enough to work with one of his daughters. If it was, you know.
Let me ask you this, he said that were you able to get a reinstatement on the board that as long as you could pass through the Walgreens hiring process, that you would have a job back with them or with Walgreens?
Correct, and this came from his district supervisor. The day that Luke told them that I was being suspended, I couldn't practice, the district manager and the pharmacy supervisor, and so I'm sure you guys are for everything, were at the store to do a store walk. And this email was right in front of them, and Gary was my pharmacy manager, and Kevin Scarborough, my store manager. And the words that they used were shocked, that they couldn't believe it, but they heard 6 felony counts, just like I heard when I first heard this. And despite that, without knowing the whole story, just based on Kevin's recommendation, from what I understand from his district manager, that they're willing to take that on.
I want to move on to the incident that happened in Arizona and kind of walk the board. You're out there doing rotation, for final rotation. And
One of the
one of them, and you get on this dating app called what?
bubble example.
And how does Rumble work?
Basically, it's one of those scan and swipe type of applications where you look at a person's pictures and bio and decide if it's somebody you want to meet, and you swipe right if you do, and left if you don't.
Here's what, right, if you do, what do they have to do before the conversation can even start?
So the way the matches work is if I swipe right on a person that I'm interested in, they also have that opportunity. And if they swipe left, nothing happens. If they swipe right, we do what's called a match. So we match. On dating apps, that's when conversation or chat would start. On mobile in particular, it was designed by women because they don't want to creepy factor. And they make it so that women have to initiate the conversation on that.
What were your search parameters while you were looking for companionship in Arizona?
So since this was a casual relationship, I wasn't looking for anything long term. Search parameters are basically no age restrictions, no age restrictions, no religion restrictions, no political restrictions, just
What about the people on there that are minors, how do you tell that?
so minors aren't allowed on there. It's actually in their terms and conditions that you must be 18 to be on that. And Bumble is one of the few that actually offers a verification process where they'll ask you to give them a sign or take a picture of yourself in a certain pose so that they know you are who you actually say you are. The search parameters don't even go below 18 because even though I believe Arkansas age of consent is 16, you still have to be 18 on that.
Let me ask you this, so you decided where were maps and you met and person, now the victim, did What did she tell you about her age and how did she actually look?
So she had some very artistic looking pictures. She's an artist, as I found out later, and her pictures were not like full frontal pictures. They were just basically like looking out from the distance with, highlights and things like that. And there was nothing in the pictures that made me think that she was what she said she was.
She told you she was 18.
She did.
And she told you, she looked at to you, physical appearance.
Yeah, she was about 5'9", 5'10", and when she talked about her weight loss, she said she weighed 170 at the time, and basically fully developed. I've helped raise 5 nieces over the past 10 years, and I know basically how people live throughout stages of going through puberty and things like that, and there was nothing with her that made me question what she was doing.
And this eventually turned into a sexual encounter or maybe multiple, I'm not sure.
It was just the one time. According to the police report, she alleges that we had sex the first night that we met, which we did not. According to the Bumble app, when I asked to meet her that night, she said no, because she was on her cycle and didn't want me under that circumstance. And I said, fine. And then we made plans to meet up the following Sunday. What ended up happening was, in lieu of meeting with her, I went down to dinner with my uncle, because this is another person that I haven't really kept in touch with for a long time. Went out to dinner with him. And then just kind of chatted with her throughout the night, talking about things that you want to do or don't want to do on Sunday, those kind of things. And then right at the end of the dinner with my uncle, she said, it's too bad we can't meet tonight because I would like to meet you. And I said, well, we can meet, we just can't do anything. She said, whatever. And I told her I would let fate decide, so to speak. If my uncle wanted to go get drinks afterwards, we would go, because I had to get forward the next morning for my rotation. If he wanted to go home and go to bed, then I can come by and meet her.
Okay, so y'all met and had sexual relations.
Not on that night.
Well, what had ever happened, eventually? And when did you, Dr. McCrady's of the opinion that you knew that she was a minor before you had sexual relations? Address that to the.
Okay, so this was the reason that we had a motion to dismiss and a motion to remand. Basically, the only evidence that they could, because I could provide all the evidence that shows, even by her own statement, that she manipulated men, telling them that she was 18 to get them to go to bed. The only thing that the state was able to provide that showed that I might have, otherwise, was the text between us. And this text was in reference to our talking about fantasies and about how she had a guy that was talking to her about fantasies and that it creeped her out what he wanted to do, and she didn't want to talk to him again. Eventually, I came up with the idea, why don't you just tell him you're underage, because then he'll stop talking to you, you don't have to worry about you being the bad guy. And the next morning, she texted me that she felt like a kind of asshole. I'm sorry. She felt like an a-hole because she told that guy that she was underage and now he doesn't want anything to do with it. The detective that created this file for the grand jury, as you see, the file of texts are kind of all out of order. She presented this to the grand jury that this happened before we met and had sex at the hotel. When in fact, based on the date of the text, it was the morning after we had met. So after that text, we had that conversation and then just flipped it again.
And eventually, did she go to see her doctor from your understanding and reveal that she was having a sexual relationship with other men?
From my understanding of the police report, about 10 days after our meeting is when she had her doctor's appointment and told the doctor that she was meeting multiple men 30 years older than she was on apps, on Snapchat, Bravo, and Hunter.
And he reported that, so the man they reported to the authorities.
She did, yes. The doctor was a she.
It's not for sure. Now, Dr. McCarty is also of the opinion that these computer restrictions. But first of all, is it the defense in Arizona if you did believe the person was over the age of minority?
Yes, this was one of the statutes that I saw, that the very first statute that the attorneys, when I was looking for a legal team, supplied with. They said that Romeo and Juliet is a defense, which obviously doesn't apply to me because I'm not close to her age. And then in Arizona, if you have reason to believe that she was legal and she presented herself to be legal, then that's defensible.
Now, and your intent was to go to trial, but eventually accepted this plea bargain to the one count of
Sexual.
sexual conduct with a minor.
Correct.
And why did you just go to trial?
Because I felt like I was the only one that wanted to go to trial. When we were motioning to dismiss and remand back to the grand jury based on the evidence that the detective had gotten along, basically. They were very embarrassed. That's why when we replied with the plea bargain, they actually made that deal even better because of the grand jury. However, she told me that if it was going to be remanded, there still would be a chance that I would be charged because I never denied that we actually had sex. And so there might still be charges, even if they were defensible, but that there would be no plea after that. They would go directly to trial. So even if it was only going to be on the remand to the grand jury, one charge, to which I could have pled even better, that wouldn't even been an option. We were going to go to trial.
So you chose the plea bargain. Dr. McCready addressed some of the restrictions in the plea bargain, one of those being the computer restriction, how that might affect you as a pharmacist. Can you address that to the board?
I can't.
You
So-
you have your computer with you right now.
I do.
You can use a computer.
I can't use a computer. And the way this, because as they've understood, the Beggins List, the sex offender registry, was crippling back when it first came out in 1996. And statutes in every state have gone further and further to kind of make those more reasonable for people. Because somebody who unintentionally sleeps with a minor should be treated as somebody who attacks their own relation against her will. So they have different classifications. And the classification that I'm in, they understand that basically everything nowadays is done via computer. So online banking, Wikipedia, things like that. What the restriction is I can no longer be privy to any kind of adult websites or pornographic websites, any kind of dating apps, any kind of app that they don't even restrict Facebook and Instagram, but that would definitely be monitored if I was going to get permission to go on there. That would have to be with written permission. And in that case, they would be privy to any chats that I have. They basically want to know that you can live your life on a computer, you just can't meet people because it's students.
Now, let me ask you this. So that's one restriction. Also, for the 10 years to abstain from use of drugs and alcohol. And this,
Yes, per probation, for Arizona's probation, I have to show up twice a year, and in which case they do drug and alcohol testing. But probation in Arkansas also was random, and I will be subject to any kind of testing that they want to do, and if I refuse, then I could be remanded back to Arizona. Basically just sent back, and then they would decide what to do, which they already said.
the ladies is, when you're on probation, they just come up and the door, so they won't around. Getting assessed on all of that, had warrants and all of that.
Correct, yeah, I have any right to warrants for any kind of inspection they want to do in my house. If they want me to show up, if they want me to drive to Texarkana from Mountain Home and be there in 3 hours to take a test, I have to figure out a way to do that.
Let me ask you this, are you also subject to random lie detector tests?
Arizona probation requires me to do a polygraph at the initial assessment, and then once a year after that.
And
Their remote probation explained to me in Arizona, this is for, not just to catch you because they don't ask as many, probing questions as they do on your initial assessment, but it's for prevention as well, because if you know you're going to be subject to this, then you're going to get something.
now, you responded, exhibit, one, if you took the plea bargain and this sentencing order came out, that plea bargain is issued by the court. Correct. Okay. Now, the sentencing order talked about probation and those types of things, but it said, sexual conduct with a minor undesignated, felony, and that is to be treated, as a misdemeanor. On the third page, so. But you did have to register on the sex offender, register, correct?
I will have to once, on this process.
You're in that process of giving, do you have any idea of what type of level on that register you'll be? There's different worse levels, like you said, for worse crimes, and then there's lower levels for less worse crimes.
Yes, sir. So the tiers in Arkansas are tiers 1 through 4, with 4 being aggravated rape and 1 being, maybe picture sharing, or in this case, my crime falls into this as well. Based on the age of the victim, since it was a child, it was a minor, things like that. Tier 1 is only privy to the sheriff's department and to state boards and backgrounds, things like that. So if the public wanted to look up my name in the tier 1 in Arkansas, they would be able to find it because only tiers 2 through 4 show up.
And, but you do have to tell the sheriff and the Richards probation office and do all those things in the county where you're living.
Yes, for Arizona probation, they told me that I can travel back to Arkansas where I own a home. By the 22nd of September, I had to have checked in with probation and I had to have checked in with the sheriff department to register.
And did you bring a letter from the sheriff saying just that?
Yes, I have a letter from Deputy Tilley of the Sheriff's Department in Baxter County. When I went to register, I had until the 22nd, to see that date on the 19th. Then I went ahead of time to register. She let me know that until we are officially accepted by Arkansas probation, that I will register completely, but that I still have to abide by visitors' rules and regulations, that she gave me a copy of that, and I check in once a week with her, and she's also said in her letter that I've done that as well.
So if you get your license back, you're gonna have a school manager and district supervisor that are gonna know exactly what went on. You're gonna be around other employees, cameras and all of that. What about giving vaccinations to children?
So in Walgreens, and I imagine CVS too, we don't give vaccinations to people under 18 unless they're maybe travel vaccines or something like that. In Walgreens, as you know, Arkansas allows pharmacy technicians to give vaccinations now. So there is conceivably, and a store as busy as ours, we always have at least 2 or 3 techs. And in most cases, that they go pharmacists at the time. There could conceivably be no opportunity in which I would have to be along with a minor. And if that's the case, one of the probationary terms is my supervisor can take a class and sign an affidavit saying that he's willing to monitor me if that situation were to arise, and he's agreed to do that.
You see also where the judge from the sentencing order designated your conduct in this case as non-dangerous,
Because I have no history of any kind of crime.
So let's, we've gone through the plea registration and how the incident started in the first place. I think we've gone through your references. What are you asking the board to do here today? And why do you think the board should do it? Something would be safe if they did.
I put myself in the board's position when I go through this process to begin with, because my initial reaction, of course, was this is a lost cause. But then I thought, okay, if the board only knows the side of the story that the police presented, then it makes me look like a horrible man. But there's a lot of discrepancies in her stories. However, I never denied that it happened. I never denied that we did have sex. So by that law, I did break that law. And so what I asked the board is to take into account the conditions under which that law was broken. The fact that there's no history, I never even had a speeding ticket. There's no reason to think that this is going to be any kind of ongoing problem. And a part of the fact that I know that I'm going to be monitored continuously, I can apply for probation, 3-year probation in 5 years based on 10-year designation. And that's my job. My job is to do everything I can to get out that probation as far as possible. I have everything to lose and everything to win in this case. And there's nothing in me or my background or anybody that knows me that would say that I'm anything at risk. Having said that, if I were in your case, in your shoes, I would be wanting to know what can you do if we were licensing you, because the stipulation is that it can't be no contact with minors. I want it to be known that contact with minors is direct contact and contact with anybody else, which means if a sick 14-year-old came to the pharmacy and asked me to give her some kind of counsel, I couldn't do that, but I can give the mother counsel, in which case I would probably do that anyways, because the mother's the guardian. As far as vaccinations, there's ways that I can not have to be in that position. In fact, 8 months that I worked, I'm ready to give a vaccination to anybody who's at the time. And apart from those parameters, there's also remote pharmacy, there's also hospital pharmacy, in which case the only people that would be under would be in the pediatric ward, and I would just not work in the pediatric ward. There's also veterinary pharmacy, there's ample opportunities for me to keep practicing and underserved areas.
Now, you're basically asking the board for a second chance, would you be willing to bring any conditions, additional conditions that the board would want to place on you?
As you can imagine, the sex offender treatment and the probation are very strict. And I understand that since I wrote the law, I'm subject to that. I have to pay the punishments, intentional or not. If I could go back, of course, I wouldn't do it if I knew any better. But the fact is it did happen. And so I have to take that punishment. When the two came, this is what they said I had to do. I said, fine. And I would be willing to do that with the board as well. If you guys need me to prove to you in any other way, if you want to monitor me over part-time to begin with to see how it works and make sure that my supervisors are in agreement with what I say I will do, I'm willing to do whatever you guys need.
Thank you, that's all I have. Pastor,
Council.
Yes, thank you. Afternoon, Dr. Dix. So where were you, when this incident in Arizona occurred, where were you living at the time?
I was at school. I was staying in an Airbnb.
I'm sorry,
I was staying in an Airbnb.
in Arizona?
Yes.
You were visiting and you got on Bumble, met this young girl. Your defense is that she presented herself as being older, correct?
Right.
And you stated that is the valid defense in Arizona to a charge like this, correct?
As far as I understand this.
And you said you're the only one that wanted to go to trial, correct?
I say that, I don't know if that's the case. My criminal attorneys were making the plea so, like, they wanted to make it so good that I had to accept it, and then the prosecutors obviously overloaded and don't want to go to trial. That's not for me to say.
Your prosecutors, you know, it's Dr. Dix.
Sorry about that.
I used to be a deputy prosecutor.
But based on what my attorneys have told me, they told me that pleas are better because they get their convictions and they don't have the cost and time of trial. So I don't know for a fact that that's true. I only know what I know.
Okay. And so but it's nevertheless, you sounded ready to go. You wanted to go into court and argue your case, right? Present your defense. You took this guilty plea, though, correct?
Correct.
So and as I said, I was a deputy prosecutor. I know how that works. Tell me if this happened. You had to get up in court, get under oath, and tell the presiding judge, I plead guilty to this. Did you have to do that? Did you have to tell the judge what you did to get these charges filed against you?
No. My criminal attorney said that he's pleading guilty to this because this is what happened. I think she said something to the effect of, he's saying that he knowingly had sex with her, knowingly for something like, or had reason to believe that she was underage.
And you agreed with that when you took that guilty plea, right?
I pled guilty.
So you pled guilty to that offense. And the probation order, I know Mr. O'Quinn has read part of it at the top of page 3. He's read that part pursuant to Arizona statute 13-604A, except as listed below. This offense shall be treated as a misdemeanor for all purposes until such time as the court may actually enter an order designating the offense a felony or a misdemeanor. It keeps going though, until and unless the court the offense is designated a misdemeanor, it shall be treated as a felony for the following purposes only. 1, placing the defendant on felony probation. Are you on felony probation, Dr. Dix?
As far as I know, I don't know.
But it's 10 years. At the most.
Yeah,
You say you have a shot to get it taken up, get it done after 5, but it sounds like at minimum you're going to be on probation for 5 years.
right.
It's a mighty long time. Number 2, DNA collection pursuant to Arizona statute 13610, did you have to have DNA collected?
I did.
Number 3, determining the defendant's right to possess a firearm under chapter 31. Can you possess a firearm right now, Dr. Dix? Number 4, being used as a historical prior felony conviction. Number 5, being admissible for impeachment purposes. Number 6, being used to enhance a sentence. Sounds a lot like a felony to me. You're not an attorney, so you can't possess a firearm, you have your DNA collected. You're on probation for at least 5 years. And let's talk about the sex offender registry. You said some things about Arkansas sex offender registration. Have you actually been evaluated here?
No,
Yes. So what you said about you might be as low as a 1 or a 2, you don't really know that, do you, Dr.
I don't know
Davis?
for a fact.
Because it's not just the offense, I mean, it's the offending pattern, it's the level of the sex offender dangerousness, need of community members for information to enhance their individual and collective safety. I'm reading for everybody's knowledge from Arkansas Code 12-913 and sex offender registry statute. Have you had a chance to look at that, Dr. Dix?
I look at it as much as I could, yeah.
You will have to register as a sex offender here if you get over here, correct?
Correct.
You have checked in with Baxter County, the sheriff's office, let them know that you will be coming. You have done that.
I have the letter showing that I did.
That's good. You've done that. So. You said earlier in your testimony that you had a good mind for analyzing things and thinking through things. Is that correct?
I like to think so.
Well, where was that when you met up with this girl?
That was non-existent at the time,
Thrown out the window.
because I obviously made that decision.
That decision to have sex with a 15-year-old girl. Yes,
It
ma'am.
would be a bad decision to have sex with me.
Which is what you pled guilty to. You submitted a statement to the board. It's in exhibit number 10. There's something you wrote, you're like to call attention to. It's on the third page of the statement. It's in the middle of the middle of the page, it's in the big paragraph. Starting at the very end of the third line, going into the fourth. I basically, allegedly, and unintentionally committed a victimless crime. Is that how you see this?
That's how I sent it to the board at the time. I do know that I made a mistake, and I own up to that. I know I'm being punished for something that I did, and that the punishment is justified.
So you now say you were wrong when you sent this statement and said it was a victimless crime?
The way I thought about it at the time is that she was the one initiating the contact with all the men, and the one that was promoting it, things like that. As I've gone through the process and understood the legal aspect of it from my lawyers and things like that, the fact that a minor can't make those decisions willfully tells me that the effects of my actions make her a victim.
As a witness.
Board, have any questions for this witness?
Yeah, I have one question. I think I saw in the record somewhere that the girl's age at the time of this event was 15, is that correct?
This number question. This witness. All right, so can you just
part of your theory is that the board of pharmacy does not have the authority to invoke under unprofessional conduct.
I'm sorry, sir, I don't know if that's the case. I defer all the legal questions to my lawyer as far as what the statute actually means. So if you guys feel like you want to not grant me my license based on that, I don't have any objections.
You're not unfamiliar with the concept that based on your crime, that the unprofessional conduct applies.
I see that.
That it's good or that it's tax.
Once again, my lawyer explains to me that, that in itself can't be used to disqualify me, so.
Okay, well, under tab 4, so under exhibit 4 is the consent agreement that you had with the state of Arizona. Okay. And under their alleged violations, if you look at a copy here, page 6 of the alleged violations. So bullet 1 under alleged violations says the board, so this is referring to the Arizona board, possesses subject matter and personal jurisdiction over the respondent. So they're saying that this is within their jurisdiction. Could you read bullet 2 for me, please?
Yeah, the board may discipline a pharmacy intern who has engaged in unprofessional conduct.
Okay. And then read bullet 3.
The conduct and circumstances described above violate the notification requirements of the statute, which constitute an act of unprofessional conduct under ARS 32.
Okay. And then read bullet 4.
Respondent's failure to comply with the board subpoena as described above constitutes an act of unprofessional conduct under ARS 32. Failure to comply with the board subpoena or failure to comply in a timely manner with the board subpoena without providing any explanation to the board for not complying with the subpoena.
All right. And the findings of fact are summarized beginning on page 4. Are they not? And so this is the subject of page 4 of the same. So the findings of fact are, they begin to summarize there. So that is the subject matter on which this applies. And did you agree and accept this consent agreement?
Yes.
And did you sign it? David?
Yes.
Okay. Thank you. Well, I guess, and this may be a rhetorical question, but how would this be different from what our orders consider?
I would agree with you.
If that's Arizona law that you put under, Arkansas has a specific law saying you can no longer use vague and generic terms. And that's the difference in normal.
If I can follow up that with Mr. O'Quinn. I understand you're continuing the new law prohibits us from using, at least your argument, prohibits us from using the section that says any act involving gross immorality is being too general. I understand that. Are you also saying the new law applies to the other section of any felony listed under 173102?
Yes, sir. I'm saying about the first, clearly, the new law of 2019 says board can no longer use just generic terms. I'm gonna find that, right here it says, if I have the wording correctly. What I've got right here. So this is basically the Right to Work Act. And the first thing that would make that act apply for him, the law that the board's relying on says any felony listed under 17, they said 2, but it's 3-102.
Right.
So I go to 17-3-102, which is the new law from 2019. And it says sexual assault in the first degree, second degree, third degree, and fourth degree.
And he clearly qualifies under the fourth degree.
Well, there is a provision for one misdemeanor if it's fourth degree, but there's also a felony class D felony. So he's not rated as a class anything, he's an undetermined felony.
Yeah, but as I'm reading the Arkansas law, it's parallel to that. There's only two requirements. You need to be above 20 years of age and have sex with somebody that's less than 16. That's what the Arkansas requirement for sexual assault in the fourth degree is.
It's just my legal arguments, Mr. Simpson,
Well, I
I'm
understand.
preserving it.
Are you saying that the new 2019 law overrides the specific list in the Arkansas statute?
This is a specific list in the Arkansas, this is the list that our statute refers to, so we do have to look at this list.
I
Of
understand. I understand, but I'm thinking your argument with the new law is just applying to the general, what is it, gross immorality or general language like that, not the specific list.
Now, it's a specific list, I'm saying his conviction in Arizona was an undetermined felony, not a class A, B, C, or any of that, and it should be treated as a misdemeanor. That's what the judge said, so, you know, and I'm just reading what our law says. And then the second part of the law, to answer your question, it says a licensing entity shall not, on as a basis on which a license may be granted or denied, use vague or generic terms, including without limitation, the phrases moral turpitude, good character.
Yeah, I got that part, it's the specific list part. And it seems to me like our law specifically says that, sexual assault of the fourth degree counts as one of the things where we have to exclude somebody from license.
If you agree with your interpretation, yes, it does. And then you would need a waiver, which is what he's also asking.
And you would agree with me that we're not here today seeking a waiver, we're here today contesting the determination of eligibility.
We're doing both, sir.
No, we're not following the process of just seeking a waiver.
That's what I said in my opening statement, is that we're here to, you know, first, we don't think the statute applies. If the board disagrees, then we would seek the waiver.
If you're here seeking a waiver, do you acknowledge that Dr. Dix is in fact ineligible for license?
If I'm incorrect in what I think the law is, and you know, everybody is from getting the legal business, if someone doesn't see it that way in court, then that license does apply, and if that's the way the board sees it, then that statute does apply, and then you would have to get the waiver, which is, if the board's gonna apply the statute and use your interpretation of it, then he is here for the waiver, and that's what he asked for. So, but you gotta preserve you gotta preserve your legal arguments in the record. You have to do that.
Right, but if he is ineligible and he has to seek a waiver, we're not going through the process of seeking a waiver that's set out in our rule 11-00-0004, which includes, among other things, going before the board's internal review committee, as well as submitting all kinds of information that I haven't seen.
Well, technically, he's seeking a reinstatement of his license that he agreed to voluntarily not practice, in your opinion, of his attorney, so he could come back and tell the board what this side of the thing is about.
Okay, I got you.
Any other questions by the board? I don't see any here. Look at the screen. Any questions by council? Do you have any redirects?
Dr. Dix, did you have a letter sent by me to Dr. McCready in October 17th, 2022?
Yes.
And can you read the conclusion? That we have to work into that letter?
Dr. Dix respectfully requests that the board consider the specific circumstances of this matter and grant him a messenger review.
That's all.
I know what records, I don't think it's in the records. If that's gonna be part of their case, I've asked that full letter be introduced to the record.
Not evidence, it's just saying that that's our request is for this hearing. The whole reason for it is that we say that we don't think the law applies, but if it does, we want to waive it. And that's what we're here doing today. And no one said you need to do this other procedure. This hearing was set for that.
That's fine, I just.
Withdraw your objection.
Yeah, sure.
This is, let's get through recross before we get back to the board's pre-questioning. Do you have anything else on redirect?
No, so we read.
Do you have any recross?
No regrets.
Mr. O'Quinn, will you? It's the seventh page in my packet. It has a number 3 at the bottom of it, but I believe it's the plea agreement. Will you read me the second bullet point on that page?
Number 3.
It reads 3 at the bottom,
Yeah. Okay.
not item number 3, the second bullet point, right above numbered item 3.
Okay. This offense shall not be designated a misdemeanor unless until defendant has successfully completed all terms of probation.
Anything else on the board?
We're on the record, correct?
Yes. It seems there are no other questions from the board. Anything else, council?
Nothing for mine.
Okay, do you rest at this time?
Yes.
Any rebuttal?
No rebuttal.
Closing arguments?
Yes. Mr. President and members of the board, we're here today, however you slice it, the ask being made is from Dr. Diggs. He wants a full unencumbered license here to practice pharmacy in Arkansas. He wants reinstatement in spite of his criminal conviction. From a legal standpoint, I wholeheartedly disagree with Mr. O'Quinn's arguments that the statutes do not apply. Number one, the unprofessional conduct language. Yes, I know what 17 chapter 3 says. When I remember when that bill made its way through the legislature and got signed into law. But one of the goals was to remove moral turpitude or moral character. Vague and generic phrases, as he said. And I'll tell you another thing that Act 990 of 2019 did. It went through statutes for licensing boards all throughout Title 17 and removed those specific phrases that it was intended to take out. You know what remained in your statute and lots of other board statutes? Unprofessional conduct. You want to consider it, you can. But let's forget that. You have 17.3.102 and what its statute, what it provides is disqualifying offenses. You know what one of those disqualifying offenses is? Sexual assault 4. In Arkansas, that was a person over the age of 20 having sexual intercourse with someone under the age of 16. Dr. Diggs pled guilty to that. Remind you, he pled guilty in Arizona. Yes, the sentencing order has some things throughout about it can be treated as a misdemeanor for certain things, but a felony for others. He can't have a gun. He's got his DNA in the system as a convicted felon. That can be used as a felony conviction for criminal history purposes. He's on felony probation. He may not know that it is, but at the time of probation of at least 5 years, that's felony probation. He's a convicted felon under the law. So that is a disqualifier. It's up to you to decide whether you want to give him a waiver or not, whether the information he's provided is enough. That is your discretion, that is your authority as the board to do so. You can decide what you had to say today, whether that's enough to prove he's worthwhile and trustworthy to have a license, or whether you want to keep him from practicing here. That is totally in your authority, and it is 100% legally sound. Thank you.
Okay. Thanks the board for their time. I think our position is clear and it speaks for itself, so I'm not gonna go through all of that, but as a matter of law, I have to make and preserve certain legal arguments. And one of those was under 17.3.102, that what he was convicted of in Arizona is not equivalent to what's listed in section 18 of that. Some people may disagree, this board may disagree and say, no, we think it's 4th-degree sexual assault. And so then that would make him need a waiver, which he's asking for that. Also made the second part of that legal argument that vague terms were eliminated by this new statute, and they give 2 examples that say it's not limited to that. And so we're saying the term unprofessional conduct is vague. You can fit a lot of things into that if you wanted to. So basically, if that's the board's position and decision, then we're here seeking a waiver based on the testimony that's been offered today. And he is not asking for an unrestricted license. He said specifically in his testimony that he would agree with additional restriction, but he's not going to be out in the community or in the pharmacy running around without law enforcement watching him, without checking in, without a probation officer watching him, without his boss, supervisors watching him, and they said they would send in updated reports and things of that. So he's going to have eyeballs on him. And so, yes, the board's duty primarily is to protect the public health and safety. But secondarily, if he has the ability to be rehabilitated and practice under restrictions or conditions, then he said he would certainly do that. So that's our request to the board today. We do appreciate your time.
This time we'll go off the record for the board's recess for deliberations and decisions regarding finding the fact, conclusions of law, and or the abilities to put it down. Once the board reaches a decision, we'll go back on the record.
I think I can simplify things for us. It seems to me that we have no choice but to say that he is ineligible. Our rule says that you're ineligible if you've been convicted or pled guilty of a felony listed, and one of the ones that's listed is the 2nd-degree sexual assault, which is a 20-year-old having sex with somebody less than 16. So it seems to me that part of our decision is not right. The harder part of the decision, from my perspective, is that our rule anticipates people being ineligible because of conviction like this. It sets out a specific process that has to be followed in order to achieve a waiver of that disqualification because of conviction. And that's not what we were doing today. We haven't gone through the process. If you all will look in your law book, you can see the list. It's easiest way to find it is the last thing on your book is I think it's the law book. And if you hit the little magnifying glass and search for 17-3-102, it'll take you right to that part. It's easier to back in my room. Yeah, erase that
Is this in Rule
Yeah, it's rule 11 dash 11-00-0004.
subsection B?
Yeah.
So you're saying that based on the rule, we have no choice but to deny him his license because he has felony. And then just because somebody, I mean, he didn't really ask, but just because somebody asked doesn't mean we need to give him a waiver. So I didn't hear any compelling reason to want to give him a waiver.
That's not my point.
Yeah.
My point is, we've got a process for seeking a waiver that requires certain information, and perhaps most importantly, requires going before the board's informal review committee to determine whether the applicant is rehabilitated. And the conviction served its purpose and a bunch of other things, which we really haven't done. I'm simply saying that we today don't have jurisdiction to be able to make that waiver decision because it's not been presented according to our rules.
Are you willing to make that in a motion?
Well, I mean, just for discussion's sake, I would probably not be real interested in hearing a waiver period like at the next board meeting, right? I mean, this happened like less than 2 years ago. There's not been a lot of time. And he's still gonna be on probation for at least another 5 years, and the sentencing document says it's considered a felony until he's completed probation. So like, I would not be willing to consider a waiver until he is off felony probation. And I think, I mean, I just have real concerns about, and I don't understand a lot about the sex offender registry, right? There was something said about certain levels, and I understand that we don't really know what level he is, but that like, the way I heard it, which could have been wrong, I don't think it matters at this point, but he could be a registered sex offender in the public, and the patients that he's serving have no way of knowing that if he's given a certain category. And so I feel like there's an extra level of trust that pharmacists need to have. I have concerns about the whole level of contact with children, right? What if he gets a phone call? That's contact with a child. He has no way of knowing that that person on the other end of the phone, how old they are. What if, I walk in the pharmacy with my 14-year-old and I'm standing at the counter, I've left in. I just think there's I have a lot of concerns, and I would not be interested in hearing a waiver request that even if it came through all of these, the things that are in this rule, while he's on felony probation. So I just would like to throw that out there.
We have heard a lot of things today. We've talked about compounding, we've talked about the FDA, we've talked about controlled substance, we've talked about the DEA, we've talked about the application of those laws, but all the things that we've talked about directly relate to the practice of pharmacy. Here, we're talking about laws that have to do with things that aren't directly related to the practice of pharmacy, but for the issuance of a license in order to do those things. Whether or not we are in fact priors of law, I get the sense that we're asked to interpret and make a decision. And quite frankly, I personally don't feel qualified. Harold, I'm glad you're on the board now as a member. And not no disrespect to the attorneys in the room, but I can't go and directly ask Darren or Attorney General's office or the hearing officer for advice. But I can I can get that at least from you, just to understand. So if what I'm hearing is correct, that we are not in a position to hear a waiver process because we don't have the information. And what we're actually doing is determining whether we're going to give them the license off suspension. And so for those things, that limited purpose, based on what we understand, that to me would seem to be the only real action that we can take. And I mean, there would be a follow-up process. This gentleman could go to the circuit court, who apparently would be in a better position to hear some argument. We're a bunch of pharmacists. So I just feel inadequate in determining at the level, other than understanding that the interpretation is that we're not prepared for a waiver process today. And that for purposes of giving the license back, that it goes against what our law says.
And there are certain things you do that give up your rights to practice pharmacy. And this is one of them.
License is currently suspended. So we will vote today and then give an opportunity. She's got an opportunity. I don't know if we want to take no action to remove the suspended state.
Our rule says a person is not eligible to receive or hold a pharmacist's license if they plead guilty, etc. So this is purely an eligibility requirement, it seems to me.
So since the license is currently in suspended state. There's a process outlined for anyone that wishes to request.
You can also appeal the revocation to.
Yeah, and I think certainly Mr. Quinn's argument is correct about the 2019 law on the rag and so forth. You know, that's an issue that a court could take up. I'm not saying that, I'm just saying our interpretation, I think, is that the rule renders him ineligible on the license.
Anybody have any other? David, you good?
I am good.
All right, I guess we'll go back on the record if we are ready for a motion.
We are back on the record in this matter, and I'll turn it over to the chair for a motion.
Yeah, we're not.
Matter of Chad Henry Briggs, P 15392, case number 2022-042. Four finds of allegations 1 through 10. True. Charge 1 is proven. Motion that we vote. This license.
Have a motion for the revocation of Dr. Dick's license. Is there a second?
Also,
Dr. Newsom seconded. All in favor, please raise your hand and signify.
Aye.
And all opposed?
Okay. Let the record show the decision was unanimous. Council, if you can please reduce the board's decision to writing and make service on all parties. If the respondent appears to appeal the decision, an appeal can be taken under any specific provision relating to this board under the Administrative Procedures Act found at Arkansas Code annotated 2515-201 et sec. Unless there are no other questions or comments, this hearing is concluded and the record is closed as to this matter.
We appreciate advice time. Thank you.
Three more hearings. One is here.
Oh, we got.
Question?
basketball parties. Whatever.
We're good.
All right, you ready?
All right. Ms. Ricks, how do you say your first name? Shaniqua. Always try to get first names right, even though when it goes to the record, it's not. Anyway, that's right. So Shaniqua? Okay. All right, good afternoon. My name is Adam Jackson. I am the hearing officer today in the matter of Shaniqua Ricks. PT 99635, case number 2022-063, which has been heard before the Arkansas Board of Pharmacy. Today is Wednesday, October 19th, 2022. With the respondent, please identify yourself for the record.
I'm Shaniqua.
Ms. Ricks, are you aware that, or are you representing my case today?
No.
I was assuming since someone wasn't there. Are you aware you have a right to have counsel with you should you so choose? Did you receive a copy of the order and notice of hearing?
Yes.
Okay, and you ready to proceed?
Yes.
Yes, okay. Will the board's counsel identify himself for the record?
Assistant Attorney General Joe West for the board.
Okay. For the benefit of anyone present today who may not have appeared in an administrative hearing, the board will base its decision solely on the evidence presented here today. This hearing is held under the Administrative Procedures Act, which means that the strict rules of evidence do not apply, and the parties will be given latitude in introducing evidence. This is to promote a fair hearing and provide the board with adequate information to make a decision. To ensure the efficiency of the proceeding, I will grant objections or caution the parties only as necessary. If there's anything that you have in your possession that you want the board to consider, you must offer it into evidence today. All participants of the hearing should be aware that the proceedings are subject to the Freedom of Information Act, and as such, all parts of the hearing, including the deliberations of the board, are open to the public. It's important that all persons necessary to the hearing are in the room during the hearing. If a party, attorney, or board member needs to take a break or leave the room, please advise me and we'll take a break in the hearing. Who are going to be our witnesses here today?
Dr. McCray.
McCray, Ms. Ricks, I'm assuming you're going to testify on your own behalf? Yes, okay. And do you have any other witnesses that you're going to call?
No.
Okay. So let the two of you, if you want to raise your right hand, I'll just sworn in real fast. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, let the record reflect both witnesses have been sworn in. Are there any preliminary matters need to be addressed, counsel?
Yes, Mr. Jackson first asked that judicial notice be taken of all governing statutes that govern the board and all rules promulgated by the board under those statutes.
Okay, so noted.
Additionally, there's an exhibit packet contains exhibits pre-marked numbers 1 through 5. I believe a copy has been provided to Ms. Ricks. Would ask those be admitted into the record of published to the board at this time.
Any objection?
I don't get what you said. Say it again, I'm sorry.
What I said or what you said?
What he said.
Ms. Ricks, that exhibit packet that has been handed to you, I would like that to be introduced as the board's evidence
Okay.
and allow the board to look at that and consider that as we review your case.
Okay.
Any objection?
No.
So noted.
That's all for me.
Ms. Ricks, do you have any evidence you'd like admitted at the outset?
No.
Counsel, open statement.
Wait, opening.
Ms. Ricks, at this time, you can give an opening statement, or if you choose to defer your opening statement to the start of your case, you can do that as well.
Okay. Guess I just. I start the case.
Defer. Okay. Counsel,
Thank you. Call up Brandon McCray.
the record reflects what was sworn at the outset.
Thank you. State your name for the record, please.
Brenda McCready,
Dr. McCray, who you work for.
Arkansas State Board of Pharmacy,
How long have you been employed by the board?
since December of 2011.
What do you do for that?
assistant director.
And in addition to serving the board as assistant director, you're also a licensed pharmacist?
I have been a licensed pharmacist since 1986.
Thank you. And in your capacity as board assistant director, are you familiar with this case in which the respondent, Shaniqua Riggs,
I am.
and Exhibit 3 is voluntary surrender that she signed, is that correct?
That's correct.
Can you tell the board what led up to that?
The board received information from her employer that she had been terminated for misconduct in the form of theft of time and wages. Walmart sent what we have as Exhibit 5, which is the time clock punches. They're kind of hard to read if you're not familiar with Walmart's time clock punching, but if you turn over to the 4th page, there's a synopsis of those. On 4/14/2022, she clocked out for lunch at 10:19 to 10:55, but the store video shows she was actually at lunch from 11:37 to 12:43. On 4/15, she clocked out for lunch at 3:05 to 3:35 p.m. Video shows she took lunch from 12:22 to 2:02 p.m. 4/24, she clocked out for lunch at 4:50 to 5:29 p.m. Video shows her on lunch from 12:58 to 2:10 p.m. 4/26, she clocked out for lunch at 1:36 to 2:09 p.m. Video shows her on lunch from 12:21 to 2:12 p.m. 4/28/22, she clocked out for lunch at 4:16 to 4:88 p.m. The video showing her on lunch from 12:15 to 2:14 p.m. The next page is information regarding the case. It talks about their wage and hours policies, what the recommendation was with termination. The next page was a statement from Ms. Ricks. It says, I clock out usually at 12:30. On my phone, sometimes it doesn't work, and I have to clock out later and I fix it. I did ask Ms. Tuskison with Walmart for a statement, and she said she checked with the pharmacy manager and confirmed that she was scheduled to take 1 hour lunch breaks. However, she was clocking out for 30-minute meal breaks while she was still in the pharmacy working. When time for her scheduled lunch came, she was not clocking out and leaving for an hour to an hour and a half to 2 hours lunches.
And as a result of all of that, she terminated by Walmart.
She was terminated by Walmart. We received paperwork and asked her to surrender our license to the theft time.
That theft of time, what board's regulation of that fall under?
It falls under professional conduct.
That's laid out in the order.
Yes, it is.
So she signed the surrender document, but what did she do after that?
She did file for an appeal.
That appeal is contained in Exhibit 4.
Yes, it is.
Was that a timely appeal?
Yes, it was.
Matter of fact, looks like it was submitted just immediately after she signed the surrender, is that correct?
Pretty close, yes, sir.
What's staff recommendation on this case?
The staff recommendation is to let the surrender stand and not reinstate her license.
For the aforementioned violations that amount to unprofessional conduct?
Yes, sir. And fraud as well.
And so it's stealing time, basically.
Yes, sir.
And at the risk of asking an obvious question, why does that fall under unprofessional conduct?
Because it's that.
Anything else about this case you want the board to be aware of?
No, sir.
Pass the witness.
Ms. Ricks, do you have any questions for this witness? Does the board have any questions for this witness?
You're aware with Walmart, the Walmart press charges or they just turn it?
I do not.
Any other questions from the board? Right. Council, any? Ms. Ricks, any further questions of this witness as a result of the board's question?
They did not pursue charges.
Counsel, anything further from Ms. Ricks?
No, that's good. I'm very soon.
Subject to recall? Send out subject to recall. You rest your case at this time.
Rest your right for all of this.
Ms. Ricks, would you like to now give your opening statement?
Just tell what happened.
However, this is your time to present your side of the
Okay.
case, so however you so choose.
My name is Shaniqua Reed, so I've been taking this shit for about 10 years. Started with Walmart, ended with Walmart. Hopefully it's not the ending, but, I'm sorry, I'm nervous. But, I know I made a big mistake. I never did deny it. I never denied it. Like when they called me and asked me that, I told them it was true. Like sometimes I need to get like out. I wasn't on the one, but yes, I was just plotting out for 30 minutes. I mean, I just hope like, we hope we took it and understand it's policy. I mean, that's why I really worked hard for it, for this license. If I know I did something wrong, but it's
Counsel, any cross examination?
No questions.
Does the board have any questions for this witness?
I do. Why did you do that?
I say the first time it happened, I did extra to get too like that. Like I did until I was ready. I was like, oh man, look like that. And I hit up. When I looked back up, I was like, well, we like that. I guess I shouldn't have did. I really just don't know why I did. But it was different. A lesson learned. Definitely a lesson learned.
What were you doing on these long times when you were out there? Because it took a 30-minute lunch to get you gone for an hour, hour and a half.
Well, the manager actually knew how long I was gone. She was actually, our time was getting cut back. So she was telling me to take hour and a half lunch break. Sometimes I was scheduled to take an hour and a half lunch break. I just wouldn't clock out for an hour and a half. Because I know that it's wrong. She knew she was okay with it, us being gone. Like I said, I know the wrong part was I should be clocked out for the time. That's what proper time is.
Was she telling you to take an hour and a half, like, just get a 15-minute break if you want
No,
to take
I-
it?
They were cutting hours for Walmart. And so if she couldn't schedule, I was taking hour, I was scheduled to take hour and a half lunch break. You know, it cut some hours back.
You said you've been a technician for 10 years.
Mhm.
How long did you work for Walmart?
Students.
Been with Walmart all the time. And I want to ask you a question about so the dates that they're showing us in my packet is April 14th through about May 5th. So about a 3-week time period. Is that the only time that you did this, or is this
Yeah,
something that
definitely
you?
started.
So you only did this for about 3 weeks
Yeah,
in the 10 years? that you've
Well,
been here?
it started then, I wouldn't say it's finished, because it went until like May sometime.
Thank you.
Any other questions for this witness?
The method of clocking in and out, because it was reference to, it would work on cell phone, is it a batch swipe, is it an athletic? clock?
They, recently went to an app where we had to clock out.
So what have you been doing since Walmart terminated you?
Working in the nursing home.
Like as a nursing assistant?
Mm-hmm. Certified nursing assistant.
I have one question, and you may have partially answered this a minute ago, but so if it just started in that one time frame when they found all of these things, what was the reason you were doing it? And you were doing it almost every day. What was the
Yeah.
reason?
Basically, like I say, I did get the clock out one day. I said, I ain't gonna lie. Plus, I feel like I got away with it. I continue doing it.
That's still unanswerable.
Why? I did it. So I would say I would just say why. I just, like I said, I got the clock out. When I came back to work, I just clocked out. While I was at work and I come back in.
But was it to get extra money on your check, or was it to take longer lunches, but what?
Yeah, get extra money too.
Was it just because you got away with it? Then you thought you'd just keep doing it? I mean,
Yeah, never from, I know it was wrong.
How do you clock out for lunch at the nursing home?
We automatically say 30, they automatically say 30 minutes after.
Take a 30-minute lunch?
Yeah, I don't have a choice but
What were your working conditions?
I'm sorry.
What was the working conditions in the pharmacy?
They were okay.
You got, there were enough, technicians working on the workload?
Yeah.
When you realize that this was wrong,
I definitely, like, this is the biggest mistake I ever made, because like, I love being technician. Cause I realized, just like I was told, that like, and this is punishment, like, I didn't work at Walmart, like. I know, it was very wrong.
So the board have any other questions for this witness? So is there no further questions? Mr. Ricks, do you have anything else to add? Any cross counsel? Do you rest your case at this time? Closing argument?
Briefly, members of the board, we have the Walmart investigation, so we came to you for testimony. You've heard the recommendation of staff. Staff recommends affirming the surrender, denying the appeal. That is what the thank you.
All right. You have a closing argument?
I just hope y'all give me this gym, like, honestly. Like, I know I'm messed up, like, I never make a mistake. First of all, this is embarrassing, because like I actually just leave and you just, it's crazy. I definitely should be it.
At this time, we'll go off the record for the board's recess for deliberations and the decision regarding findings of fact, conclusions of law. Once the board reaches a decision, we'll go back on the record. We're all ready.
I can't, I'm sorry, I can't really make anything out you were
I was
saying.
just, okay, what I was saying, was she facing burnout? And I had asked her what she doing those, on those long breaks, and I really didn't get an answer. I didn't know if she was overworked, wasn't enough staffing. Just wasn't able to pull as much information from her, that I needed to hear.
Mhm.
well, we've heard 2 Walmart cases there. Right?
Yeah.
And, I mean, in as much as Walmart has this corporate culture, there still seems to be their own little culture inside of each store. It doesn't seem to be consistent. I'm not gonna advocate and say that she was right. But, I mean, she said she was wrong, very specific share of made. I'm not on the table. Personal.
You feel different as you kind of taking money out of cash register?
She didn't.
This is stealing time. It's just like stealing merchandise. It just happens to be time. Stealing.
I get your analogy, and it would
It's
be
not
what,
about $12.
Yeah, and my thing is what the root cause. But all things like this, when you start having, or basically a psychological break somewhere. What's the root cause? What was the trigger?
but I would rather see her take money out of the registry than I would want to see somebody being knocked down in the hallway.
I just think that it ain't up to us to keep up their time clock. They need to handle it in a different way other than sending the infractions to the board. They need, you know, if they don't like the way they're showing up for work, they need to get rid of it.
And I spoke to.
They'll violate before the board.
It was a termination, so anytime.
I mean, just because you get terminated, you have to.
Yeah, but-
A for cause termination. So the for cause termination, you have to know that the board is held for one, and because it involves.
But it doesn't require somebody to come forward.
No, we asked her, the board asked her to surrender her license because she had been terminated from theft, which is unprofessional conduct, right?
Theft of time, it is. It's a nice way of putting not being at work when you're supposed to,
It's to be paid for something you're not.
as far as we know.
Uh,
I mean, we don't know if she got paid for it anyway.
the video evidence.
Oh.
It says, I mean, it says the video.
You're asking for people that all these companies come for us because they stole time.
I'm just saying what's in the case, in the information presented to us, says that there are video evidence to show.
And I'm saying that that is in there for a reason. That reason is not valid.
I don't know, I mean, we've had cases before where in a retail setting, the manager had some weird concoction to reverse out returns and they were taking that money, right? And it's like this willful, like intentionally stealing time. When you look to me, when you look at these times that she was clocked out for lunch and the times that she was actually at lunch according to the store video, like they're not even remotely the same. It's not like she forgot to clock out and then she forgot to clock back in when she got there. Like sometimes the periods don't even overlap at all.
I don't disagree with you. She
So to me, she was
was not there,
intentionally
but I'm
trying
saying-
to clock out for 30 minutes, but be gone for as long as she wanted to.
Right, exactly. Mhm. Oh, I agree that is intentional, just like stealing, where you try to steal from the register, because when she would think of it, she would do like a 30-minute clock out. So that looked like she just left for 30 minutes. But then I'm sure the pharmacy started wondering, where is she? She doesn't ever come back. So they looked on the video and found out she's gone for an hour or two every time she leaves. So it's stealing time, intentionally stealing time.
I think the question, I understand your point, but I think the question we have to answer today is, do we feel like if we were to accept her request for an appeal and give her her technician permit back, and she goes to work in another pharmacy, are we confident that she's not going to steal from them too?
No, but I'm not confident anybody can go over that, I'm Steve.
I mean.
Next time it might be Xanax.
Okay.
You're gonna do it again,
But this is not even worthy of our attention. It's small. I'm not sure we'll work on that. We'll do that. Can't get that because y'all should work. That ain't my problem, sir.
If she wants to work as a technician, I think that's what she's here.
Cool text,
Yeah. Let's take it off. Debbie, you have anything to add?
I missed that last thing you were saying. Have y'all made any kind of decision
No,
Okay. No, I mean, I think we look at it like any theft case. Do you want someone that steals to work in the pharmacy? Period. It wasn't a mistake. It wasn't an accident.
Well, she admitted that.
Yeah.
She got away with it once and she purposefully did it first.
Right. So we'll do. I can't move it, so.
Take a straw poll, just to take the temperature of the board to see where we're going.
All right.
I, for one, don't think this is a matter that the pharmacy board has anything to do. I think this is a past and a future employer issue or a criminal law issue if they're criminal charges.
I think time clock theft is a little bit of a gray area for me compared to actual outright theft. Because if she had worked, the company would pay the money. If I go steal merchandise off the shelf, then the company's out regardless. So I do think there's a difference. I'm not justifying it, I'm just saying there's a difference. In my mind, I think this is more of a violation of policy and procedure, more than like a criminal case like shoplifting. So I would be inclined for reception.
And, my thing is root cause. As I was looking at now at, what's going on in pharmacies. To make people quit or something happen to them, or even when we start doing stupid stuff. What is the root cause? When I start digging and taking the layers off, what's really wrong? And I did not prove that here. And so I'm on the fence. She wants to go back to work again. Without her license, she cannot have a second chance and work in another pharmacy.
It does show some, poor choices, and we've taken action to protect the public, based on poor choices. Also, there's something said about the, intentional, scheduling of longer breaks to, cut hours to save hours, and so, if that's the case, there could have been, we don't know, but there could have been some thought that, well, I have to have the same income, my cash flow has to stay the same, so I'm gonna clock out for the same amount of time that I've always been clocking out for, even though on the schedule I'm supposed to have a longer break, so that my cash flow, I don't know. But does all of that warrant revocation of the permit? It's 258 minutes.
About 8 hours.
David?
So Dr. Jolly, you were saying you saw it, she wasn't coming out ahead in her money, but she was not working the amount of hours she was getting paid for and intentionally doing that. So to me, I get it. It's a little tiny different than stealing something, put it in your pocket and you gained from it. But she gained by getting to go home and do something for an hour and a half or 2 hours where she should have been, she stayed on the clock. She should have been working on the clock. But we've had a lot of theft things. I know Harold is brand new on here, but we have had a lot of different kinds of theft. All kind of theft comes in front of us. And when they have a technician license or a pharmacist license, we do hold them in a higher caliber that they need to be honest and they shouldn't steal, because if once you start stealing, it can turn into also stealing drugs. So we have had a lot of this. This is a unique one, but it's not anything new for our board to see a lot of theft cases. I would not be in favor of keeping her tech license.
Three. So again, all right, so who is in favor of taking the 10 ones? One, two. Two votes. Two votes are interested in the rest or not. Is that what I'm seeing?
And I would make it feel which that was.
You know, just a point of clarification, just based on something that he said. I'm not saying she didn't gain something, she did gain something, she didn't pay for not working, right? But I've worked with people that don't do anything at the end of the day, either while they're on the clock, if they're not working, so I just think it gets into a little bit of gray area, that's all I'm saying. As opposed to taking money out of the cash register or. And I understand Nick's point, because we have to terminate technicians from common attendance, like too many sick calls. And would that be something that we would revoke? You know, a technician coming over just because they're terminated. So I understand this specific point of view.
This side of the table did the math, and it adds up to 4.3 hours. We go back on the record, I'd like to answer a question. Go back on the record. Ms. Richard, you understand what you did. Are you gonna do this again?
No,
Are you gonna steal from, no matter who you work with,
no,
Tom or anything else?
no.
And just rhetorically, let it float out there that, I mean, you might consider making restitution all on your own. Just go to them and say, here's your money back. Just a thought.
All right, off the record, please.
Go off the record.
So do we have a motion? Do we have anything that anybody would like to make to move this wagon down the road a little further? Citizens. Go ahead. All right, we'll go back on record.
Go back on the record this minute.
All right, the matter of Shaniqua K. Ricks, pharmacy technician number 99635, case 2022-063, allegations 1 through 8 being true, and charges 1 and 2 being proven. Despite that, we're willing to reinstate pharmacy technician license.
We have a motion for Dr. Richmond to reinstate her pharmacy tech license. Is there a second?
So,
Motion is second by Harold Simpson. Is there any further discussion on this matter? All in favor, please signify by saying aye. Show of hands, please. 5. 5 ayes, all opposed, please.
Aye.
We have 2 opposed. Motion carries.
So by a vote of 5-2, motion carries. Council can please reduce the board's decision to writing and certify all parties. Since technically respondent won this one, but if respondent cares to appeal the decision, the appeal can be taken under any specific provisions relating to this board on the Administrative Procedures Act and Arkansas Code Annotated 25-201 et sec. If there are no other questions or comments, the hearing is concluded and the record is closed.
Okay, you got your license back, we don't see you here anymore.
I approve you.
And make restitution. And if the company is unwilling to accept your money, give it to the sheriff. And put it in, I guess the building right now, just be drop it in the Salvation Army budget. They'll be bringing in a few weeks, but give that money back and make yourself all right. Okay.
Judge, when you go to the case. 5:30. Set a quick recess.
last two have no response and not showed up, so we will not take it.
And it won't take long, but, and I would park in the parking deck at the AG's office, which is valet parking, they throw our keys in a lockbox, so we can't get till 6 a.m. tomorrow morning. So we don't get home, we don't get our keys real fast.
Tonight will not be a good night to walk on.
So, well, on call order, they're not here. So we'll go through without being, they'll be quick, they have to be keys. So we still have to go through the process, like, but they'll take 10 minutes. Yeah, you have to read it. Yeah, I remember that now. You gotta put break.
Okay, but that's something. Can they have a,
They can use our data too, but it's next door.
okay.
They say,
Okay, okay. But it looked like there were two this morning we didn't do either. Did y'all do anything? So there's 4 show
Let's go.
All right, microphone is on. Debbie, can you hear us? Good. Let's go.
All right, Joe, which one you got?
Stephanie Berganza. And while we got that, William Wallace has been continued because he was involved in a car wreck and I will do that February day.
Berganza.
Berganza.
Okay. My name is Adam Jackson. I'm the hearing officer today in the matter of Stephanie Berganza, PT13564, case number 2022-069, which is heard before the Arkansas State Board of Pharmacy. Today is Wednesday, October 19th, 2022. At least I think it's still Wednesday. Respondent is not here. Procedurally, you have to go sound the hall. Let the record reflect, however, having just come from downstairs and up the elevator and in the hall, there is no one there. Let the record reflect for the purpose of procedure that I have gone to the hallway, sounded for Berganza, no one answered to that name. Council, is that satisfying procedural?
It does,
Issues?
it does. I'll address service or witness testimony as well, but.
Okay.
Good.
In that case, council, can you please identify yourself for the record?
Joe West, Assistant Attorney General on behalf of the board.
All right. So I still have to go through the abbreviated version of the explanation of the proceedings. For the benefit of anyone present today who not appear in the administrative hearing, the board will base this decision solely on the evidence. The hearing is held under the Administrative Procedures Act, which means that the rules of evidence do not apply. To ensure the efficiency of the proceedings, I will grant objections or caution parties only as necessary. Counsel for the board, if you have anything you want more considered, you must present it here today. And as always, these proceedings are subject to Freedom of Information Act. If anyone from the board or any of the parties need a break in the proceedings, please let me know. We'll take a break. Counsel, who's going to be a witness?
Brendan Craig.
Okay, Mr. Craig. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I did.
The record reflect the witness has been sworn. Counsel, any preliminary matters?
Yes, ask the additional notice we taken of all governing statutes and rules, taken up on the board. Additionally, there is an exhibit packet containing 12 exhibits, move that we introduce into the record and publish to the board at this point in time.
So noticed and so committed.
That's it.
Counsel, wish to proceed your first witness.
Sure, call Brendan Craig. Thank you, Dr. Craig, this is your name for the record.
Brenda McCrae,
Who's your current employer?
the Arkansas State Board of Pharmacy.
What do you do for them?
I'm the assistant director
How long have you held that position?
since December of 2011.
In addition to being your assistant director of the board, are you also a licensed pharmacist?
I've been a licensed pharmacist since 1986.
Your capacity as assistant director, are you familiar with this case against pharmacy tech named Stephanie Berganza?
I am.
And real quick, exhibit number 2 is the proof of service. Ms. Berganza is absent. I see 2 envelopes in there. Can you tell the board what those are?
These are envelopes showing that the order notice of hearing is mailed both by certified mail and by normal U.S. post. And I've also spoken with Ms. Berganza on the phone and had emails back and forth as recent as Friday.
And did she acknowledge that the hearing was today?
She did, and I told her if we did not have the surrender by Friday, we would do that.
Address you sent the notice to, is that the best address the board has on file for responding?
Yes, it is.
And did the mail come back to the board?
No, I did not.
Is this case related to the Valeria Beltran case we heard for this board? heard earlier today.
Yes, it is.
Matter of fact, it's Ms. Braganza, one of the texts that was involved in that.
She is.
Can you summarize for the board what happened?
We received an email from the owner and PIC and pharmacy that she had 3 technicians that were sent home from work because they had ingested marijuana edibles while at work and were impaired. The technicians were 2 others and then Ms. Bergonza. They were sent home. They came back to the pharmacy the next day and were terminated. We received a statement from the pharmacist that actually came in during the day, which is under exhibit number 10. It said that she asked Carla where Stephanie was because she hadn't seen her. She said that Audie had brought in a wheat brownie and Stephanie ate it. Carla told me Stephanie wasn't feeling well enough to work, so she went home that day. She asked if Stephanie was aware that it had wheat in it. Carla said she didn't know. The statement goes on to talk about the other technicians that were also involved. There are email, text messages back and forth between Stephanie Bergonza and one of the other technicians that under exhibit 7, where Stephanie says, "My body is so numb. Are they normal or not?" The other text said, "Who's normal?" Stephanie said, "They're not normal." As you proceed down, she said, "Who's gonna work now?" And Stephanie joked that she didn't get cake. They went on and she said, "Would you check on," Stephanie Bergonza said, "Would you check on Audie? She's not okay." The text said, "What?" Like she's mumbling on the phone to me and she sounds weird. And she's in the break room with Lee. The other text said she's gonna confess to Lee and Stephanie said no. Stephanie said, "Please go check on them." And if you fast forward to a couple of pages, it talks about all of the technicians were high. Crystal, one of the other texts says, "So did she just share, so you think she shared it with Stephanie at work and had none herself? She's the one who provided it." So based on the information that we received from the pharmacist in charge, as well as the pharmacist that came into work that day, we provided the order notice of hearing because they were all working with their uniforms.
And you previously testified that they were terminated as a result of this.
That's correct.
Was it offer to surrender the license then?
We did send an order, an offer to surrender. It's under exhibit number 4. And the proof of services under exhibit number 5. And that also was sent, both certified and U.S. mail. When I spoke with Ms. Berganza about the surrender last Thursday on the telephone, she said she would sign it and send it to me. I told her I didn't have it by Friday, and we proceeded with it.
And does ingesting marijuana and then working while as a tech while doing so constitute unprofessional, dishonorable conduct?
It does. It's also a violation of controlled substance laws.
Anything else?
That's all.
All right, absolutely.
Any questions for this witness?
We talked about 2 cases being connected. There was a 3rd person involved. Have we got anything with that case on?
The 3rd person surrendered her license and
The 3rd surrendered and she's not trying to get it back. Just the first one was trying to get it back.
she did not appeal this notion.
It's exhibit 11.
Yeah, her surrender is exhibit 11.
Which one of them brought that in? Do you remember who started it off?
The technician is surrendered originally.
Any questions? Smack, you have any questions?
No.
Anything further, counsel? No. Okay, what's your case this time?
ask them, stand down and witness, rest of those.
Close argument.
Briefly, board, you got, this is third. Tech, who did the same thing. One has already surrendered, the other, the board, you all have already taken their license for sake of consistency. I argue that you should do the same here and revoke Stephanie Berganza's license. And I promise this is the last time that I hear about the marijuana brownie at the community pharmacy in Springfield.
At this time, we'll go off the record for the board's deliberation, regarding finding fact and conclusions of law. Once the board makes a decision, we'll go back on the record.
Go back on the record.
Okay, we're back on the record.
I can make a motion.
I got it. In the matter of Sharonda, oh, I'm on the wrong case, sorry, hang on. I was looking at the wrong file.
We can go back on the record.
I can't make money.
No, we don't. I just had to pull her out. Okay. In the matter of Stephanie Berganza, pharmacy technician PT 13564, which is case 2022-069, the board finds that allegations A1 through A6 are true. Charges C1 through C2 are proven, and I make a motion that we revoke her pharmacy technician permit.
Second.
A motion by Dr. Mitchell to revoke the lady's license, second by Debbie. All in favor, please say aye. Aye. Any
Aye.
opposed? Any opposed?
Let the record reflect the decision is unanimous. If council can reduce the board's decision to writing and make a written service for all parties. The respondent carries to appeal decision, taken into any specific provision relating to this board under the Administrative Procedures Act found in Arkansas Code annotated 2515-201 S. If there are no other questions or comments, this is concluded. The record is closed as to this matter. What's the last one?
Sharonda Rogers.
Number 10.
Same question.
We all want to.
You already? Okay. My name is Adam Jackson. I'm the hearing officer today in the matter of Sharonda Rogers, technician applicant, case number 2022-097, which is heard before the Arkansas State Board of Pharmacy. Today is Wednesday, October 19th, 2022. Respondent is not present for the purpose of the record. Let the record reflect that I am going to the hallway and sounding for Ms. Rogers, or calling for Ms. Rogers. Everyone here about the name of Ms. Rogers? Rhonda Rogers. Rhonda Rogers. Let the record reflect, I have returned from the hallway where I sounded for Ms. Rogers. No one answered to the call from Ms. Rogers, so we will proceed. Council, is that satisfied?
It does, and there will be additional discussion of service during the case.
Okay, thank you. If you can identify yourself in the record.
Assistant Attorney General Joe West, representing the board.
All right, give an abbreviated explanation of the proceedings. In the benefit of anyone present today may not appear in an administrative hearing, the board will base its decision solely on the evidence. The hearing is held under the Administrative Procedures Act, which means that strict rules of evidence do not apply. The parties will be given latitude in introducing evidence. To ensure the efficiency of the proceeding, I will grant objections or caution the parties only as necessary. Counsel, if there's anything you have in your possession that you want the board to consider, please offer it today. As always, these proceedings subject to Freedom of Information Act, which means that all parts of the hearing, including the deliberations of the board, are open to the public. Anyone who needs to take a break during the hearing, please advise me to take a break. Council, this is going to be a witness.
Brendan McCray.
Mr. McCray, do you swear or affirm the testimony you're about to give to be the truth, the whole truth, and the truth? The record reflects Mr. McCray is sworn in. Council, preliminary matters.
Yes, Mr. Jackson. First, I'd ask that judicial notice be taken of all governing statutes and rules that govern the board in this matter. And additionally, there's an exhibit packet containing 8 exhibits. I will move to introduce these to the record and publish them to the board at this time.
So notice and as it fails.
And additionally, in the order of notice of hearing, allegation A8 needs to be struck. That was A8 and A5 refer to the same arrest and charge. So an A5 accurately states the final disposition of that charge. So A8 needs to be stricken from the record. There was no felony forgery conviction.
So paragraph 8, I can have oral motion to amend and describe.
Correct.
Does that need the board's vote or can that just be stricken by motion?
I think it's to be stricken by motion because it's not supported by anything in the record, so the board cannot make a finding of facts consistent with that.
Okay, that is sufficient.
Or I guess when the time comes, I'll ask them not to consider A8, whatever needs to be done.
Council, you may proceed with anything else you or with us?
That's it. I'm on my first witnesses.
Sorry. Remaining allegations are not in my.
No, the remaining allegations are in the record. It's only A8.
Are there any missing? Because there's 2 A6 and then it goes from 6 to 8 and then 13.
13 should accurate. Yeah, A8 should have been A7 and A13 should have been A8. Yeah, there's some screws.
2 A6s.
Yeah, it goes from or actually, I'll take that back. There's 2 A6s. The second A6 should be A7. A8 needs to be thrown out in its entirety. A13
Should be
A8 now.
Thank you.
We'll make sure all that is fixed in the final order.
Okay. Works for me, council, you ready to proceed?
Yes, call Brendan McCray.
Record reflect Mr. McCray is sworn in. What's up?
Will you state your name for the record, please?
Brenda McCray,
Dr. McCray, who's your current employer?
the Arkansas State Board of Pharmacy.
What do you do for them?
I'm the assistant director.
How long have you done that?
Since December of 2011.
And are you also a licensed pharmacist?
I am since 1986.
In your capacity as assistant director, are you familiar with the application for a pharmacy technician license submitted by Sherrod Rogers?
I am.
And what's the current status of that license?
The application was denied due to the number of criminal convictions, and it is on appeal.
And before we get into the meat of the case, I'll direct you to exhibit number 2. It's like this envelopes in here. You can tell the board what goes on.
The proof of service, they were or the notice of hearing was mailed to their home address by US mail as well as certified mail.
Is that the address that she provided to you at the time she applied for the license?
Yes, it is.
Have either of these letters returned back to the board as being undeliverable?
They have not.
All right, well, let's move on to the application. So when she applied, did she disclose any criminal convictions?
She did.
What did she disclose?
She disclosed that she'd been convicted of misdemeanor and that she was working on having the record exposed.
What, did she say what misdemeanor charge she had been convicted of?
She wrote a statement that is under Exhibit 3. And it has to do with, where do I read? She was arrested because she was, had unauthorized use of a rental car that she was supposed to return, but she had not. She was also, the car was reported stolen. She was also charged with a felony hot check charge, and that was reduced to, and she was convicted of a misdemeanor for that.
Did she disclose this at the time of the application or only after the application was submitted?
She said in a statement when we asked her to.
So how many convictions did you discover in your background checks? I see, six shows some from district court, until the board was there.
Those were just some charges we found that, there was a pollution fear, a violation, some driving on a revolt license, just little things like that.
It was like that district court, and then
There was also a theft of property that, we found on some charges that were from, 2015, that's correct.
there was that one hold on district court theft property that showed it was passed and dismissed.
It was. None of those did she disclose, just the ones we discussed previously.
And then exhibit 7, that's the possessing extra crime. Was that put down from a felony forgery?
Yes, it was.
So 537-201, forgery, knockdown, possessing extra crime. For that unauthorized use of a vehicle, that was also put down as a felony as well.
Just,
Then obstructing governmental operations, was also holding that.
yes, sir.
It's like a misdemeanor possession of Schedule 6 controlled substance, non-cross as part of the plea agreement.
Yes, sir.
So, I understand those convictions in and of themselves were not disqualified, so why are we here today?
She would, in their entirety, they did not allow us to issue her license, and her license was denied.
And even though those convictions of each on their own were not disqualified, or was she entirely truthful when she initially submitted her application?
She was not.
Because she left off some of these convictions.
That is correct.
What's the recommendation of staff on this?
That the board not reinstate her license.
Anything else about this you'd like the board to deal with?
No.
As witness.
Board have any questions for this witness? No questions? Seeing a head shake, it's not. Council, anything further?
Nothing further for Dr. Craig.
Close an argument or
Rest, briefly close board. This is an instance where Ms. Rogers should have been truthful up front, laid everything on the line. She might have a license today, instead she didn't, and given an opportunity to present her case, she's not here. So I would ask that the recommendation of staff be followed.
at this time, we'll go off the record for the board's recess for deliberation, as defined in spec, conclusion to the law.
I- I can make a motion if we go back on the record.
We're back on the record.
Okay. In the matter of Sharonda Rogers, case 2022-097. This is gonna be complicated. A1 through A13 are true, except A8 is gonna be taken out. And then C 1 through 2 is proven, and at this time, with her not even attending this hearing, I recommend we do not let her license be granted.
So we have a motion by Dr. Mack, do we have a second?
Second.
A second by Dr. Jolly, all in favor, please signify by saying aye.
Aye.
Any opposed? Let the record reflect.
With the record reflect the decision is unanimous. Court's counsel can reduce the decision to writing and enable written service for all parties. If the respondent cares to appeal the decision, appeal can be taken under any specific provisions relating to this board under the Administrative Procedures Act of Arkansas, annotated 2515-201 and set. If there are no other questions or comments, the hearing is concluded and the record is closed.
That's it for today.
Are there any-